Imagine thinking you should not have been fined under a city ordinance and then being told, oh no, you're not allowed to challenge that ordinance. We're asking the Supreme Court to please consider a case to fix that. Hi, I'm Stuart Shepard, and this is First Liberty Live. Thank you for liking and sharing our videos and getting the word out about the things we talk about here. They matter to you. They're going to matter to your friends as well. Our guest today is Nate Kellum. He's senior counsel with us here at First Liberty. Hi, Nate.
Hello, Stuart. Good to be with you.
Glad you're here. This is an interesting case because it's really in two parts, so I want to lay it out that way. First, there's what happened, and then there's the legal issue that we're taking up to the Supreme Court. First, I want to talk about what happened. What is it that Gabriel Olivier wants to do? What is he seeking to do there in the park in Mississippi?
Yeah, we have the pleasure of representing Gabe Stewart, and he's a great guy. But more than anything else in the world, he wants to tell others about Jesus Christ. And so he lives in the Brandon, Mississippi area. And really a unique opportunity for him to reach people is in the public park there, where there's an amphitheater that's located there. Also, there's a lot of grassy areas. There's a lot of places where people go. And so he wants to go outside of the amphitheater and try to reach people for Christ, basically share the gospel, tell people about local churches, and just visit with them about their views on Christianity. And so to do this, he goes to the park. He tries to either, sometimes he preaches, sometimes he hands out literature, sometimes he holds up a sign. But in all these ways, he's just trying to tell people about matters that matter most to him.
And it may be a T-shirt, it may be a sign, it may be a sermon, and we all may have opinions about that. I mean, we have feelings about that. Oh, I don't want to be bothered by a street preacher, that kind of thing. But I think we all would agree he certainly has a right to do that under the First Amendment. This is literally what it's about, is the ability to share your opinion in a public place with other people, right?
Yeah, that's right, Stuart. And certainly there could be some people, hey, I just want to go see the concert. But of course, they could just keep walking. They don't have to talk to Gabe. He doesn't try to force his views on anyone. He's just looking for willing people who are interested in visiting with him. And that's really it. Of course, you have folks who are trying to sell pizza or maybe someone else who has something to say. Maybe someone's concerned about something that's going on in the amphitheater. They can share that as well. It's just a fundamental right that we all have, and that is in a public place where we have the right to walk, we also have the right to talk.
Okay, and this is where then it becomes a conflict because the city said, nope, you can't do that here. You have to go where? Where did they send him?
Yeah, this is the rub, Stuart, is that he goes to this space where he can reach people, and the police officers say, nope, you can't be here. You have to go some 300 feet away.
Wow.
In this square box, and so that puts them way out of the way of pedestrian traffic, so they can't converse with people. They can't hand out literature with people. No one could see their expressive T-shirts. And in addition to that, they even, while within this small box, they put additional restrictions saying, well, your sign has to be a certain size. You can't even step on the step stool to make your sign more visible. If you wanted to use amplification so you could reach people, you can't speak so as to be heard beyond 100 feet, even though they put them beyond 300 feet of where people are located. So essentially they're saying, we do not want you to be heard. We do not want your message to be seen. And that was a real concern for Mr. Olivier.
So it's really not a free speech zone. It's a we don't want to hear your speech zone.
That's exactly right. You can go where people don't have to hear you or see you.
So Gabe went over to that space, couldn't talk to anybody because it's just him over there. So he decided to go back where the people were, and that did not go well. Tell us what happened next.
It did not go well. The chief of police showed up in a golf cart, and he reminded him about, hey, we have this new law, and this is where you have to go to this remote space. He tried to explain, well, first of all, he's not a protester. The way the law reads is supposed to apply to protesters. He's not about protesting. He wants to evangelize. And then also he explained to the officer, well, when I go over there, no one can really hear what I'm saying. No one can really see what my signs, and so I'm not able to effectively communicate. the chief was nonplussed. He said, well, this is the law. You have to follow it, and you really have to leave. He was trying to converse with him about the constitutionality of it. And that's when the chief really lost his patience, and he arrested Mr. Olivier, and he had to go to court.
All right. And they fined him for this under the city ordinance. Tell us what happened next.
Well, he paid the fine, but he wanted to go back. And so he really knew that there was something terribly wrong about this law. He knew it was unconstitutional.
Yeah. And if I can interrupt just briefly, he didn't say, I'm guilty. He didn't plead guilty. He did what it's called a nolo contendere or something like that, where it says, I'm not pleading guilty or not. I'm just going to pay the fine and move on, right?
Right. That's Latin for no contest. And essentially what that means is, okay, I'll just pay the fine. He's in front of a state court municipal judge who's not really suited to hear constitutional arguments. And of course, the law, the way it read, it did regulate him. It did tell him to go 300 feet away. And so he figured that the best place for him to challenge, bring a constitutional challenge, would be in federal court. So he just paid the fine with full intention of challenging this law in federal court.
All right. So, Nate, I'm not an attorney, but I can tell you with total confidence that so far this is not making sense to me because it's a free speech issue, cut and dried. But this is where it gets to the legal part of this, the other part of the story that we talked about at the beginning. He wanted to challenge the city ordinance, so he went to court, and then the judge said, no, you can't do that. Walk us through that. What happened?
Sure. It was under a Supreme Court doctrine. It was the basis of dismissal. The court dismissed his case without even considering the merits of it, Stuart, without even considering, is this law constitutional or is it not constitutional? The court didn't even get to that part. What the court said is, you have no right to bring this claim. And it was under this case called Heck v. Humphrey, which is a case about whether prisoners, those who are in prison, whether they can bring constitutional claims about their sentencing or about their conviction. And in that case of Heck v. Humphrey, what the Supreme Court did is it held that, no, you really can't do that because there's another avenue for prisoners. They can bring something called a habeas corpus. It's something that's designed specifically for prisoners, in which if they feel like they've been their rights have been violated in some way, that the conviction was wrong, that there's some conspiracy, or that the sentencing was too great, they can challenge those things through the habeas corpus. So the court held, okay, if you want to do it, you have to do a habeas corpus. But what happened here, because he was charged, because Mr. Olivier was charged, and he paid a fine, Stuart, they held, yes, Heck v. Humphrey applies, and therefore you cannot bring a claim.
So, and I'm going to read this back to you, and you tell me if I've got it right. Habeas corpus is the idea of, I'm imprisoned, I don't think I'm imprisoned correctly, so I have a right to go to a judge and say, I shouldn't be here, at least tell me what the charges are. Am I right so far?
That's right.
But in his case, he paid a fine, went on his way, so he's never in prison, never in jail, never locked up. Basically, they're saying, but that's the path you have to go, but you can't go that path either because you're not in jail. So he's at a place where he can't go either direction, right?
That's right, Stuart. He literally cannot not win for losing here because they say the only avenue that he would have would be habeas corpus, but he had no access to habeas corpus because he was never a prisoner.
Okay, so that's what we're taking to the Supreme Court. Let's talk about that. What, if you could help us, for those of us who are not legal experts, help us understand what we're asking the court to do in this one.
We talked about how fundamental the right to speak in a public way, or something that's even more fundamental is a right to be able to bring a free speech claim into court. And so that's really what's at stake here with this cert petition, where it really deals with, can he get his day in court? Can we get to the point where the court can consider is this ordinance constitutional or not? And as it stands, he's not allowed to do so. So what we're doing is we're challenging this interpretation of this doctrine out of Heck v. Humphrey, and we brought it to the Fifth Circuit Court of Appeals, and they denied Mr. Olivier. They said no, it does right. Heck does rightly apply here. And so we brought what's something called an en banc petition, and that's another fancy Latin term, but essentially what that means, Stuart, is we're trying to ask all the judges at the Fifth Circuit, instead of just this 3-judge panel, all the Fifth Circuit judges, what do they think about this issue?
Yeah.
And it was really interesting, Stuart, because it was split. It was a 9-8 decision against us, saying that Heck v. Humphrey should apply here. And so that really shows that there's a huge dispute about this. And so we decided to take this matter really the only place we could, and that is up to the Supreme Court. So we filed a cert petition asking the U.S. Supreme Court to weigh in on this very important fundamental issue. Does Mr. Olivier have his day in court?
So to help people understand, a cert petition is us formally asking the court, please take our case, and now we're waiting to hear back whether they will, correct?
That's correct. So the Supreme Court, they only accept certain cases, and the way it turns out, they only accept a handful of cases of which they're pursued, and so they choose. And so we think our case, though, is very compelling. That even though they only accept a very small percentage, we believe this is something they'll seriously consider because of the rights that are at stake.
Now, I want to acknowledge our friends at Gibson Dunn that are joining us in this. Tell us about the work they're doing on this.
Fantastic work. It is really, truly a pleasure to work with Gibson Dunn on this. They're one of the more prestigious law firms in the country, and yet as volunteers, Stuart, they're helping us out with this cert petition. And so their name alone carries a lot of weight, but also they provide some of the best work in the country.
Yeah, and I understand other groups are signing on to this and sending in their own briefs saying, please take this one.
That's right. And Stuart, you can probably appreciate this. Amicus briefs are hard work. It's not easy. This is something where you have to do a lot of research and writing, and lawyers tend to be busy. And so you're really, it's a big ask when you're asking someone to do an amicus brief because you're not paying them for it. In fact, there's Supreme Court rules that says you cannot pay them for it. And so you're asking for a favor here. Hey, we believe this issue is important. If you agree with us, will you file a brief that supports us? And so it's something that's hard to do. Also, it's hard at this stage because the Supreme Court hasn't decided whether it's going to take the case or not. So they don't know if the Supreme Court will even get to the merits. It's just a matter of will they take it. But despite the difficulty of that, Stuart, we've had a tremendous response. It looks like we will have either 10 or 11 amicus brief, and that is really almost unheard of. And so we're really encouraged by that. And what it tells us is that, yes, this is an important issue, and many others from really, I would say, from various ideologies agree that, this is something the Supreme Court ought to consider.
I want to give you a chance. I don't know if I doubt any of them are going to watch this, but I'll give you a chance to. If you could make your personal appeal to the justices on the court to hear this case, what would you say to them?
Well, I would probably not say much different than what we've already discussed, and that is, Stuart, that if constitutional claims really mean nothing if we cannot bring those claims to court. And so rights only go so far as if they're just esoteric, if they're just theoretical. We really have to have the avenue of being able to enforce those rights. And the courts is where we turn. And so in order to ensure that fundamental right to be able to bring a constitutional claim, the court ought to consider this case.
All right. When are we expecting to hear something back? Do we have any kind of calendar on this?
There's not a firm calendar date to think about with this. Where we are, Stuart, is we filed our petition, and the other side, they have waived their right to respond at this point. We will hopefully get some amicus briefs filed. The April 17th is the date that we're asking our amicus friends to get the briefs in. And so once those are in, then the court will make a decision as to whether or not they will ask the city of Brandon, Mississippi, to respond to our petition. And then once they do, then the court will consider. They'll meet in like this conference room. I'd love to sit in on one of those, but I never will. But
because nobody gets to, right? It's just the 9 of them.
Yeah, exactly. And they just sit around and they talk about these potential cases. And so they'll have that discussion. And our prayer is that they will decide, yes, this is a case we need to take.
All right. Anything else you'd like to share before I let you go? You've really done a good job of explaining this. I have a better grasp on it now after hearing you lay it out like that.
The only thing I would add is that I think we're really blessed at First Liberty to bring this type of case because Mr. Olivier is really not a person of means to be able to bring a case to the U.S. Supreme Court. So we're really thankful for those who support the work that we do because it really allows us to take vitally important cases like this and hopefully get some justice.
All right, very good. And I want to point out, our clients, none of them ever pay a bill. They never get a bill from us for the services we provide. We're a nonprofit, so we depend on the goodness of people's hearts to support the work we do so that we can provide for these clients of ours that we represent.
Yeah, that's right. And it's a real blessing to do it.
All right. Nate, I appreciate you. Glad you're on our side.
Thank you, Stuart.
All right. Thank you, Nate. If you'd like to support the work of First Liberty Institute, if you just look for the big red Give button up at the top of the homepage and click on that, you can join in our efforts to protect and defend the religious heritage of all Americans, to protect religious freedom for all Americans, and to make sure that the things that you care about and that we care about are taken care of out there in the real world. First Liberty is fighting for what matters most.